The clerk will now proceed to read the orders of the day.
Extradition, Provisional Arrest Bill, Lords Committee.
No. We now move to Committee of the Whole House. Order. Order. Before I ask the clerk to read the title of the bill, I should explain that in these exceptional circumstances, although the chair of the committee would normally sit in the clerk's chair during committee stage, in order to comply with social distancing requirements, I'll remain in the Speaker's chair, although I'll be carrying out the role not of Deputy Speaker, but of Chairman of the committee. We should be addressed as chairs of the committee rather than as Deputy Speakers.
Extradition, Provisional Arrest Bill, Lords.
We begin with Amendment number 1 to Clause 1, with which it will be convenient to consider the amendments, clauses, new clauses and schedules as listed on the selection paper. There's been a slight change to the choreography, so after I've called Sir Iain Duncan Smith, it will then be David Davis. So I call Sir Iain Duncan Smith to move Amendment 1.
Mr. Chairman, thank you very much indeed. I stand to move Amendment 1, but with it will be a whole bunch of other amendments which I have put down alongside my honourable friend, the member for Isle of Wight, and the honourable lady, the member for Rotherham. These I had intended originally, when I put these down, Mr. Chairman, to speak on the basis that the government needed to act. But since I put them down, the government has acted. And that's never a bad thing. And as I may well have provoked with my colleagues them to act, I do want, however, to speak to these because there are further consequences that come as a result of this and things that are happening at the moment, which leads my hope that the government will pay full attention to further action that may be required, stretching across extradition and into sanctions. So I thank the government in this regard that they finally agreed to rule out the extradition arrangements with Hong Kong. But it is worth noting what has been going on since the imposition of the national security law, which is now making many in Hong Kong their lives a misery. And more than that, they now fear very much indeed, not only for their lives, but their liberty in a way that none of us here sometimes, I think, could possibly imagine what it is like to live in such an environment. You know, we have a historic relationship with Hong Kong, and we have a legal right under the Sino-British treaty to have an opinion and view on what is happening in Hong Kong, no matter what the Chinese government may say. That is our right in international law. And this imposition of the national security law, we know, runs counter to that arrangement, that treaty. And so on that basis, the government has acted correctly, I think, in cutting off any potential problem that may arise as a result of the use of that extradition agreement. But there is more. I mean, even now as we speak, quite recently, a number of people who have done nothing other than use the kind of rights that we would take for granted in this House. Jimmy Lai, the owner of the largest pro-democracy publication in the city, has been charged with undermining the state. Arrests of young activists, some of which we've seen on television, but others go on, and media posts holding blank pieces of paper at protests in shopping malls, they being arrested for sedition. The targeting of Hong Kong activists overseas is going on apace and gathering pace, and retrospectively applying the law to supposed crimes that took place before the law even came into force, which I find, well, perhaps I shouldn't find remarkable, but I do. And then there's all the elements, Mr. Speaker, which the UK government will find itself having to deal with. And I think all the devolved administrations, I believe, are united in this sense, that the effort around censorship is really quite astonishing. References now to the Tiananmen Square massacre have now been removed from all textbooks and all elements that may say anything at all about this. They are simply blanked out. A new cultural revolution with teachers and students now being asked and encouraged to spy upon each other where somebody may say the wrong thing, or something which is considered the wrong thing, or in retrospect may have been remembered to have said the wrong thing, these are all would then invoke the use of the security law. And there's a new National Security Centre in Shenzhen to re-educate those who do not comply with these. Benny Tai, the organizer of the Yellow Umbrella protest, a peaceful movement, and I stress these are all peaceful movements, is fired from his teaching post at university simply because he was party to that movement. And censorship of university content now is also gathering pace, as they're filleting out anything that references any concerns or issues around the nature of China and even historic nature too. And then we come to the latest issue, which will concern the government completely, because we're now seeing particularly journalists from the free world. I say the free world because this is not just a Western issue. This is an issue of all those who believe in rights and freedom around the world, whether they be in the Far East or in the West. But the New York Times now has to relocate its staff completely lock, stock and barrel to Seoul after a senior journalist visa renewal was rejected, and the threat was clearly there that the rest would follow. Senior journalists of the Hong Kong Free Press had their visa rejected, and the Foreign Correspondent Club in Hong Kong described this as a weaponization of visas by China. And even on the news the other day, we now see that the Australians are being heavily targeted, brutally targeted, not only with sanctions, but now even their journalists are having to flee the country. In fact, 2 journalists were due to leave, were then stopped from leaving, and ended up in the consulate and have now finally left, but the authorities wanted to question them for writing stuff which they didn't approve of. And then, Mr. Chairman, the whole point about this issue comes into focus because it is the cooperation of the Chinese officials that I find perhaps the most galling. The announcement that they were postponing the LegCo elections by the Chief Executive Carrie Lam, which were due to take place on Sunday the 5th of September, which is just a weekend gone. But she cited COVID cases as a reason for the delay. Now, I must say, I've heard a few excuses in my time, but this one really did take the biscuit, because so many other countries have had elections, local and national, even during the COVID saga. And it is also worth pointing out that the Hong Kong rate of infection is lower pretty much than any of the countries that have held elections already. So the idea that they can latch on to COVID as some kind of excuse for cancelling elections had nothing to do with the reality. The reality was they did not approve of the opposition, and they wanted to stop that, so they had time to make sure they arrested the key elements so they would never be able to stand. And now many of them have fled here to the UK, and I have met and seen them. So there are 2 points, really, I think, that dismantle this whole process. The point I made earlier on, which is that a number of countries, dozens, I think, have actually held elections, and this is really part of the total crackdown and the acquiescence with what essentially is an illegal process going on in Hong Kong. Which brings me also to the next phase of this. The government is right to have reacted. It is right to have ceased the extradition procedures, but there is yet more that I believe needs to be done, and I like to think that this is something which unites us all. The Magnitsky amendments, the sanctions that come from this, now need to seriously be deployed by the government. They said, the government and the Secretary of State or the Foreign Secretary said, when I was last in the chamber on this, said that they would review and read other actions that need to be taken with regards to Hong Kong, and they would take it as the situation develops. I must say, Chairman, the situation has been developing. It's been developing at a pace which means that I think, if my right honourable friend will forgive me, it's at a pace faster than the government or the Foreign Office seems to be able to move. So I would urge the government and the Foreign Office, we have nothing any more to lose by holding back on this. It's not as if the Chinese government is going to turn around and thank us for this, because they already think that we have caused problems. So my answer to this is, let's get on with this. The deteriorating situation over the summer has really accelerated. And the US government have already sanctioned Hong Kong and Chinese officials responsible for the implementation of the new law and for any human rights abuses. So I urge my right honourable friends and the Foreign Secretary, who isn't here, to move on to this and to listen to Nathan Law, who himself fled directly after the Hong Kong government did not agree to them standing. He had to flee, and others have done so too. And they've all called for those sanctions to be applied. So I do hope that the government will listen to people whose lives have been under threat, who themselves have families still in Hong Kong, and yet are brave enough to call for such sanctions, knowing full well that this may bring further problems for them. Can I also raise, related to this, another issue which is part of this process, which is the excessive and expensive visa fee costs for BNO passport holders under the present government policy, which could potentially be prohibitive for those who wish to get passports. It does seem to me that we've been generous in opening up to say that those BNO individuals who have BNO status who wish to get passports will have the right to get them and to travel, if necessary, to the UK. But we then put another problem in their way, and we don't make it easy for them. And it's sorely not right that British passport holders, but as potential passport holders, should have to face these kind of fees. So here we have BNOs that are allowed to serve in our armed forces, but yet not able to become British nationals without paying a large cost. I hope the government would think about suspending that to encourage them, and particularly the young ones, to be able to take advantage of what is essentially should be a lifeline. And many of those who I've met who have fled Hong Kong have spoken of their difficulties in obtaining those passports, and I know it's not directly my right honourable friend's responsibility, but I do hope he will raise this with the Foreign Office to give that their blessing. The last point I want to make before rounding up on this is important, that we also know that all the businesses that have been kowtowing to the Chinese government, I think in a shameful way, many of them, apologising, excusing, and saying somehow this is all about restoring order, despite the terrible abuses taking place. Many of them are listed. I won't go through them all, but I do want to raise one thing that has just recently been discovered, which is that the Disney company, it appears now, worked with the security services in Xinjiang province. Xinjiang province. People may remember that that is, of course, not province, I beg your pardon, it's a region. But that is the place that the Uyghurs have suffered the most appalling abuse. It is these very security services that have been responsible for the forced sterilization of Uyghur women. It is these very security services that have been rounding up those who have not cooperated, send them to re-education camps, which have turned into labor camps because they are now giving what I would call slave labor to companies situated in China. This is appalling, but this is an illustration, Mr. Chairman, of what has been going on in China. I mean, I'm astonished, to be quite frank, no matter all the amount of news that exists at the moment, that actually the broadcast news has been pretty quiet on this. It's high time that we actually made a fuss about this. We should be the leaders in all of this. This country has a responsibility to Hong Kong and has a right to speak out. And I simply say to those companies, Mr. Chairman, that it is shameful that they turn a blind eye. It is shameful that they act as the apologists for a regime now that brooks no dissent, intolerant, and is now arresting people for the most minor new offences which have nothing to do with normal law. So it's deteriorating. It's deteriorating fast. This government needs to pick up the pace. It needs now, after having agreed to these extradition procedures being lifted, the reality is that nonetheless, I urge my government, I urge them with all my heart to put China right up there as a priority, no matter for all our domestic rows and arguments and details, all of which are important. But the freedom of people and the imposition of dictatorial regimes should always be our number one cry. We should speak out when others are not able to have the freedoms that we take for granted in this House. And if we don't speak out for them, who will?
The question is that Amendment 1 be made. David Davis.
Thank you, Mr. Chairman. Remember the pro forma. Can I start by agreeing entirely with my right honourable friend for Chingford and Wynford Green? He's argued forcefully that we should not extradite to China and Hong Kong with powerful humanitarian and human rights reasons, and he's right on every count. Now, our extradition arrangements with the United States are not anything like as divisive as they are with China and Hong Kong, but they still remain deeply imbalanced and can lead to serious miscarriages of justice. As it stands, this bill would allow for the arrest of individuals in the United Kingdom who are extradited to a list, or are to be extradited to a list of specified countries, to arrest them without a warrant. My amendments would remove the United States from that list of countries. That's Amendments 7, 8, 9 and 10, and that's what I shall speak to now, Mr. Chairman. The government says we need the powers in this bill because of suspects getting away if they are, I quote, encountered by chance, close quotes, and it's not possible to arrest them without applying to a judge for a warrant. For hundreds of years in this country, we have woken judges and magistrates up in the middle of the night to do precisely that, to carry out a police action, whether it's a search or an arrest. And we do not bypass normal legal protections when a domestic suspect might get away. So why is it necessary for individuals facing extradition? The Home Office's own impact assessment of these new powers say that with or without these powers, suspects are highly likely to be before the court in any event when the requesting state confirms the suspect is at large in the UK. So you have to wonder why they need it at all. The methodology used in the impact assessment supporting the bill is both opaque and bogus. It's too long to go through it here, but I would recommend, if you want a confusing way to go to sleep, you should read it. It's completely useless. But even so, it asserts the proposed change would only result in just 6 individuals per year entering the justice system more quickly than would otherwise be the case. 6 individuals a year out of over 100,000 criminals we deal with in this country every year. And for that, we're giving away a fundamental legal protection to the innocent as well as anybody else. The explanatory notes to the bill try to justify the legislation on the basis it's similar to powers introduced by our European neighbours. Spain, for example. Well, let me give you a single example of that in operation. The House will know the name of Bill Browder, the man who campaigned on behalf of Sergei Magnitsky, the man who died in Russian imprisonment, effectively was killed by the Russian state. The Russians put out a red notice in Interpol for Mr. Browder, and the Spanish government executed it. Now, right enough, a judge subsequently released him. But I'd like the House to think how Mr. Browder would have felt sitting in a Spanish prison, considering the prospect that he might just be about to be extradited to be imprisoned in Russia, to be put into the hands of the people who had killed Magnitsky. So these things are not without price. As for other European countries, well, of course, a number of them actually have absolute embargoes on extraditing their own citizens to anybody outside the European Union. For reasons which I'm going to come to in a second, but which will essentially relate to a lack of trust of other countries' justice systems. The bill's impact assessment states that under the proposed new power, the police could arrest a suspect who was wanted for extradition by a trusted partner country. And the bill defines a trusted partner country as those who respect the international rules-based system, and I think broadly speaking, not entirely, but broadly speaking the United States does that, and whose red notices and criminal justice systems the UK trusts. Now, we like to think of the United States justice system as being rather similar to our own, but recent high-profile cases have highlighted just how wrong that is, and how we cannot trust the system with the interests of British citizens. When the 2003 extradition treaty and the associated bill was introduced, it was sold to this House on the basis that we used principally for paedophiles, murders and terrorists. I was the Shadow Home Secretary at the time. I remember it vividly, and I remember the leader of the Conservative Party at the time actually accepting it on those terms. because he thought it was in the interests of the country. But the people we're extraditing to the United States are mostly white-collar businessmen who pose no danger to the United Kingdom or indeed United States citizens.
Will my right honourable
Yes, I'll give way to my right honourable friend.
I'm most grateful to my right honourable friend who's making a characteristically sensible and robust speech. Does he agree with me that at the moment the international rules-based system is under very great pressure, but matters a huge amount to all of us? Isn't the example he's giving of the United States a totally asymmetric approach to extradition? And that asymmetry will be seen by our constituents and seen by people in Britain, will be seen as being most unfair and will be seen to bring this whole process into disrepute.
Well, he's right on several counts. I'm going to elaborate the unfairness in a second. But he's right also to highlight something else, and that is that rules-based systems, international rules-based systems, only work if everybody sees them treating all countries and the citizens of all countries in an identical way. If they don't do that, they fall down. So if you take an American exceptionist approach to this, you destroy the system that you're trying to uphold. So there is a rather interesting philosophical point in his intervention, as well as the moral one that I'm going to major on.
Would you give way?
Of course, I give way to my right honourable friend.
Would my right honourable friend confirm that there were quite a number of us on the opposition benches when these measures came in who were very uneasy about the asymmetry and the unfairness, and so it's good to see him reviewing this at this later date.
It's exactly right, and I was one of them, although at that time I was not allowed to say so. It won't be the first time I was overruled by my boss, or indeed the last. Since 2007, the United Kingdom has surrendered 135 UK nationals to the United States, 99 of whom were surrendered for non-violent offences. Overall, for the whole period of the Act, it has been 80% non-violent offences, so much for terrorism and murder and paedophilia. Or to put it another way, only 3 violent offences per year requiring extradition to the United States. The US deliberately uses its extradition arrangements to cast a wide legal net around the business world, seeking to be judge, jury and executioner for global commercial deals and global commercial aims. The Home Affairs Select Committee's 2012 report concludes, the United States has the power, and I quote, has the power to reach out around the world and, provided there is a very, very tenuous connection with the United States, it generally has the power to prosecute. And the distinguished extradition lawyer Robert Duncan puts it, the Department of Justice effectively uses criminal extradition as a lever for US interests in commercial matters, which is not what it's for. This has been shown in case after case. Cases such as Iain Norris, the chairman of Morgan Crucible, the NatWest 3, Christopher Tappin, and a number of others, including most recently Dr. Mike Lynch. How does it work? Once a person extradited from the UK arrives in the US, they're treated as guilty from the moment they land. They face invasive strip searches, and that is exactly how it sounds. They are electronically tagged. They're kept in appalling conditions, completely alien to the British justice system. They're shackled and perp-walked into and out of court in front of television cameras and paparazzi, so the US Department of Justice can claim a PR victory at the expense of the presumption of innocence. Some of them sit in court facing the allegations dressed head to toe in orange prison garb. They're then faced with enormous pressure from the US authorities to agree to a plea bargain. They're told if they plead innocent, they'll face decades in these appalling conditions, and if they plead guilty, they'll receive a much lighter sentence in an open prison, possibly half of it served back here in the UK. Because the case is held in America, very often witnesses from the United Kingdom will not appear, as they themselves fear incarceration. That's certainly the case in some current cases. A massive 97% of cases are settled by plea in the United States. This, for a foreigner, unprotected by the US Constitution, for a foreigner, this is not a justice system. It's a very effective, but not at all fair, prosecution system. It's not justice. Much of this would be better if the accused were tried in Britain, completely sidelining the need to extradite at all, to come back to this bill. The NatWest 3, for example, were British citizens Their alleged crime was in Britain, against a British company. At worst, they should have been tried in front of a British court, but the British authorities did not see them as having a case to answer. But the extradition treaty does not recognise this. Anyone caught in this system faces an asymmetric and unbalanced treaty process. Unlike the US, a person in the UK has no right to insist on probable cause before being extradited. The 2011 Joint Committee on Human Rights report called this a lack of reciprocity of the treaty, and it's resulted in the US only surrendering 11 individuals to the United Kingdom since 2007, whilst 135 have gone the other way. And since the United States is roughly 5 times our size, as big as the UK, this is a disparity, an effective disparity of 50 to 1 in risk of extradition.
Will my right officer allow me?
I will, of course.
It's not just a case of lack of reciprocity, though, is it, Madam Chairman? It's the fact is that in the NatWest case, which he mentioned, these people had no case to answer, according to the British authorities, and yet, in spite of that, they were extradited. That surely is an appalling abuse of their human rights.
Well, he is exactly right. I mean, there were other cases. Interestingly, in their case, human rights were not used as a mechanism of defence. In another case, the Gary McKinnon case, that was the only thing that stopped Gary McKinnon from being extradited, was the actual implementation of the human rights law. But he's right more generally. They didn't have a case to answer in a normal justice system, but they gave in and confessed to guilt rather than face 30 years in a grim, high-security Texan prison, never seeing their family again, which is what it would amount to. So that's where the disparity is and why it's so unfair. And the US government, of course, has much greater discretion in refusing an extradition request. The British Extradition Act says the Secretary of State must, the word is must, issue a certificate for extradition. The equivalent US code states the Secretary of State may order the person to be tried. May order. And of course, there's no stronger demonstration of this than the case of Anne Secoulis, the person responsible for the tragic death of Harry Dunn. In Ms. Secoulis' case, the US Secretary of State has used this discretion to prevent her extradition. And I think in the view of most of this House, wrongly to prevent her extradition. The Dunn family may now have to settle for a wholly unsatisfactory virtual trial of Anne Secoulis because our extradition arrangements have failed to give them proper justice. But this is just the latest example of how the completely lopsided treaty allows US citizens to evade justice while exposing United Kingdom citizens to miscarriages of justice. The Prime Minister himself has recognised this imbalance. At Prime Minister's questions on the 12th of February, he said, "I do think that elements of that relationship are unbalanced, and it is certainly worth looking at." Now, due to the scope of the bill, my amendments wouldn't rebalance the extradition arrangements with the US. They would, however, prevent, in a very, very small way, further facilitation of further miscarriages of justice. It would be a tiny improvement in a system that requires an entirely radical rewrite. And so I'm only putting these as probing amendments today. But the simple truth is, and I make this point very, very firmly to the Minister on the bench, my right honourable friend, my very old friend, the Minister on the bench, that this really needs... He's older than you think. This really needs, in the words of the Prime Minister, a rethink. And I do hope that the government will rethink this treaty and ensure that in future, when we extradite British citizens to any other justice system in the world, that justice system will work as it is supposed to and give them what's in the title, justice.
Yeah.
Mary Kelly-Foy.
Thank you, Madam Chair. This extradition bill is an important piece of legislation. We need an extradition system that ensures that UK law enforcement agencies are supported in apprehending dangerous criminals in order to keep the public safe, both in Britain and abroad. This bill helps facilitate the extradition of those who have committed serious crimes abroad, and as a House we can all support that. However, it is vital that this bill includes the necessary safeguards. The amendments, both from the other place and those put before the House today, share common themes of transparency, fairness and supporting parliamentary scrutiny. These are values that every member should hold. To begin with, it's right that this bill compels the government to consult with the devolved administration and NGOs before adding or removing a territory, as well as confirming to Parliament that the territory does not abuse Interpol red notices. This amendment is one that promotes dialogue and discussion amongst relevant parties, respects the role of devolved administrations, and ensures a level of transparency that is necessary in government. It's difficult to see how any reasonable government could object to that. Moreover, given the trouble that this government has had with carrying out consultations before making major decisions, it's important that this measure is included in the bill. And if any member needs evidence of this, then I'd refer them to the former Department for International Development. Similarly, the second amendment carried in the other place, which mandates that territories can only be added to this extradition process individually, is designed to increase both transparency and scrutiny. If we allow territories to be added when grouped together, there's a real risk that a country with a problematic human rights record could be included alongside countries that respect human rights. Considering the government's vocal support for a Magnitsky Act to deter human rights abuses, it would be somewhat hypocritical to oppose an amendment with the same purpose. Furthermore, by considering whether to add a territory on its own merits, we are not only ensuring that these countries do not abuse Interpol red notices, we are adding a further layer of parliamentary scrutiny to this process. As a House, we should seek to support additional scrutiny, not limit it. It's therefore disappointing, if not surprising, that the government seems set on opposing these common sense safeguards. Madam Chair, as well as the amendments passed in the other place, it's important that this House further strengthens this bill. Given that this legislation includes increased law enforcement powers with the purpose of keeping the public safe, it's right that the House should be able to see the effectiveness of these measures. The amendment compelling the Secretary of State to update the House annually on the number of arrests made will help achieve this. For the same reasons, it's important that this Act is kept under regular review by this House. Again, this strengthens Parliament's role while ensuring the measures are working as intended. Finally, although this bill rightfully updates our extradition process with territories like New Zealand and Canada, it's clearly wrong that there is still uncertainty regarding our justice and security arrangements with members of the European Union. Many of these states are some of our closest allies. While a potential lack of access to the real-time European criminal databases will undoubtedly affect the ability of UK law enforcement agencies to protect the public, and it's concerning that the government is yet to adequately address this. While this bill should be supported by this House, it's not perfect and there are gaps and uncertainties that still exist within it. The amendment tabled by the opposition seek to fill and strengthen this bill and ensure that it is fully effective, whilst also aiming to increase transparency and cooperation. I would urge members to support the opposition amendments today and to protect the amendments included by the other place. Thank you.
Sir John Redwood.
Madam Chair, there are two very important principles that should be in all our thoughts when framing extradition legislation. There is, of course, first the imperative that we want to make sure that where someone has committed a serious and violent crime, a terrorist offence or a murder or something in the United Kingdom and have escaped abroad, we wish to have arrangements so that we can pursue justice against them through cooperation with countries around the world. But we should also have very much in our mind the issues which my right honourable friend, the member for Houghton Price, has drawn to the attention of the House. We should be very concerned about innocent people in our country who may be the object of extradition requests or demands from countries abroad to take them into justice systems that are not up to the standards of our own or not the kind of thing we would want, particularly for an innocent person to have to approach, only to see justice not done in those countries if we have undertaken such extradition matters. So I do share the request of my right honourable friend for Houghton Price that we need to look again at how the US relationship is working, and it is of concern that something which was sold to this House some years ago now, on the basis that it would be targeted on those criminals we could all agree about, the terrorists and the rapists and murderers who were committing violent crime, and we discover that hasn't been its main use at all. I hope the Minister will share with the House his thoughts on what arrangements we will move towards with the other European countries now we've left the European Union. There may be a move to put all of the European Union or EA countries under these provisions, but I think we should definitely look at the different standards of justice system in those countries. Whilst many of our European friends have excellent justice systems that we would be very happy with, there are very variable standards throughout the European continent, and I think given that we are rethinking our foreign policy and our position in the world generally, this is a good opportunity to look at them one by one and to ask whether some of them are below the standards we would expect and whether they haven't made good use in the past of the very widespread powers granted to them under the European arrest warrant. When I was preparing for this debate, the one set of figures I did see in a commentary was for the period 2010 to 2018, and it said that over that period continental countries had used the European arrest warrant 8 times as often as we had used it for criminals or those alleged criminals that we needed to undertake here in our courts. And so it has been asymmetric. In part that's because, of course, there are many more people on the continent than there are in the United Kingdom, but it also tells you something, I think, about the seriousness of the offences that they're interested in for extradition. Now, I'm pleased to see in this legislation before us today that there is some recognition that extradition should be reserved for more serious offences. One doesn't want a complex and expensive system like this used for a lot of minor offences, and that the government has chosen, I think, to define it as something which is an offence in the United Kingdom and something which would command a 3-year or more prison sentence in the event of somebody being found guilty. And I think that's a good start, because one of the features of the European arrest warrant that many people didn't like was that somebody could be extradited under that from the United Kingdom for something that wasn't actually an offence in the United Kingdom, and that didn't seem to be a very fair system or proposal. So I hope the Minister will share with us some of his thoughts on what would be an appropriate list of European countries and whether they should just slot into these proposals that we are debating today. I think I'm happy with the list of countries that we are being asked to endorse today, with the caveat that I think we need to look at this American relationship in the way my right honourable friend has suggested, and I fully understand that now is not the afternoon to try and make dramatic changes in that, and I understand why he has only put down a probing amendment. We're asking the government, but I think there are big issues here which we would like them to review.
Alexander Stafford.
Thank you, Madam Chairman. It is a pleasure to speak on a bill which is so crucial to the security of our country and to the safety of our citizens. The extradition bill laid before us today plugs the capability gap that currently exists, whereby the police become aware of a person wanted by a non-EU territory but are unable to arrest them without obtaining a warrant from a court first. Due to the delay, the suspect may abscond to avoid justice or to commit further crimes, this time in the UK. It is not a point of debate that we all want to see those who perpetrate such serious crimes brought to justice, wherever they may be. Furthermore, the people of Rother Valley do not want foreign criminals exploiting loopholes in our system to commit further crime in our communities. This bill enables British police to quickly and efficiently arrest suspects without warrant for the purposes of extradition. This is similar to the powers which already exist under the European arrest warrant, and will apply to a small number of countries with equally rigorous and robust legal systems to our own. Much has already been said previously about the aim and the substance of the bill, so I wish to turn this House's attention to the amendments tabled for our consideration. My right honourable friend, the Minister of State for Security's amendment, was allowed for the territories listed in new paragraph 3A to be inserted into new Schedule A1. These territories, for the most part, being member states of the European Union. As we heard in the other place, this bill is not a move to replace the European arrest warrant or to second-guess the Brexit negotiations. It does, however, seem prudent to list these territories in the new Schedule A1, just in case we do lose access to the EAW. If other arrangements are made, this paragraph will repeal at the end of 2021, which is a good thing. I certainly support such a measure, and I follow with interest the Norway-Iceland-style fast-tracked extradition security partnership the government is currently considering to replace the EAW. The sole aim of this bill is to enable the arrest of a suspect wanted by a trusted non-EU country. Canada, Australia, New Zealand, the United States, Liechtenstein and Switzerland are not only models of good judicial practice and fairness, but also some of our key partners going forward. In addition, the highly respected NCA must be satisfied that a valid request has been made and such a warrant or conviction exists and the offence is a serious one. Given this, I note with concern the opposition's additions of New Clause 1 and New Clause 2, which require the Secretary of State to lay a report before Parliament, giving a breakdown of extraditions. This is required every 12 months and demands a list of each incident broken down by the protected characteristics of each person, as per Section 4 of the Equality Act. There is no reason to think that extraditions under this bill would be any different to those under the European arrest warrant, not least because of the high confidence that we have in the legal systems of the Category 2 territories. The new clauses tabled by the opposition are needlessly bureaucratic and place an onerous burden on the Secretary of State for little benefit. I am very interested in exploring the amendment in the name of my right honourable friend, the member for Chingford and Woodford Green, and I am pleased the government is supporting such amendment by preventing an application of this bill to the People's Republic of China and Hong Kong. After the PRC's interference in Hong Kong's internal affairs and Beijing's undermining of Hong Kong's common law system, we should not consider extradition requests from these territories. Conversely, while I recognise the valid points often made by my right honourable friend, the member for Halton Price and Howden, by excluding the United States from the list of permitted territories, I do fundamentally disagree. The US, for all its flaws, is our greatest friend and ally, which values liberty and due process above all else. To exclude them, we manifestly wrong and send the wrong message to the United States government. I do support this bill and the government's amendments, and in the words of Max Hill QC, the Director of Public Prosecution, this bill strikes the right balance between ensuring sufficient human rights safeguards and delivering the capabilities that the police and CPS require in order to safeguard the public. This is exactly what the people of Rother Valley and the United Kingdom want us to do.
Deputy Speaker, and can I first of all thank the honourable gentleman for Chingford and Woodford Green for setting the scene so very well. Many of the things that the right honourable member spoke about, and I was tempted to intervene just to have it on the record, the concerns that the honourable gentleman referred to in relation to the persecution of the Uyghur Muslims, the bestiality, the violence, the outright criminality that is taking place from the Chinese government against their own people. It abhors everything that is decent. I think it probably underlines the issue that we need to we can't do this on our own, but the right honourable gentleman knows that, but we can do it in conjunction with other countries as well. And I think while this goes some part of the way to setting the scene, I think we have to recognise that we must work with others to make it happen. So I look forward to the Minister of State. And it's nice to see him in his place again. He's doing double duty here in this house. He did it last night. He's back again for more. My goodness, you're some minister. But it's very, very, very pleasant to see him in his place. I welcome the opportunity to make some comments on this. The UK has extradition nations with over 100 territories around the world, and this partnership, I believe, is essential. To be able to ensure not only that criminals are properly processed, but also that our need to extradite and the ability to do so is subsequently reciprocated. However, it is right and proper that the Secretary of State announced in July an end to the Hong Kong Treaty, which allows for the extradition in light of the imposition of the new security law in Hong Kong by Beijing as a serious violation of the country's international obligations. I welcome the Secretary of State and the statements that he has made in this House in relation to that. Today's press, I'm not sure if other members have had the chance to check it, in the press today, the story was told of a 12-year-old child in Hong Kong who was arrested by three burly police officers, if you can say they're burly, ever mindful of their size, but they're certainly in excess of 5 times the strength of the child. The child was out getting paints for her school classes, and she was perceived to be a protester. And the actions of the Hong Kong police were totally outrageous, as they are with everyone that they do. But in particular, it rankles me greatly what I've seen and express that concern. I also declare an interest, Madam Deputy Speaker, as the Chair of the APPG and Freedom of Religious Belief in Parliament. I am very aware and very disturbed at the treatment of those who do not fit the mould of how the Chinese believe things should be done. The treatment, in particular, of the Uyghur Muslims has been in the news of late. I've spoken about it. This is something that the APPG has been reporting on for some time. The thought that the extradition treaty with the Hong Kong government could mean the inhumane treatment of many people extradited to China after a pause in Hong Kong is quite simply frightening, and it's absolutely right that the SOS took these steps. It's not only the persecution of the Uyghur Muslims, it's also the persecution of Christians who've had their churches desecrated, attacked, who have their right to worship monitored and restricted. It's also those of the Falun Gong belief as well, who have been systematically used for organ transplants, sometimes, Madam Deputy Speaker, on a commercial scale. So China has been guilty of all the worst crimes in the world against those who just don't fit the format of what they want. So therefore, what the Honourable Gentleman for Chingford referred to, I wholeheartedly agree with, and I do unfortunately see that we do not maybe take the steps with human rights within this. Again, maybe the Minister will give us some reassurance in that. I'm quite sure that he will, but I would ask him to. This, I believe, underlines the essential nature of getting it right in this legislation, of ensuring that we fill our moral obligations, and the Honourable Gentleman for Hutton, Price and Howden referred to as moral obligations, which I think we all have, but he referred to as in particular, which I also would refer to, and duties that we have the capacity to alter and change as is necessary. I fully approve any country, any government I fully condemn any government or government that carries out any human rights abuses or persecution of those of religious minorities and ethnic groups. There is a lack of the HR, the human rights safeguards, and expressing that deep concern. I see in the other place, in the background information we got from the library, it referred to that they referred to the lack of human rights safeguards. They referred to the use of wide regulation making in Henry VIII powers, the lack of specific criteria or safeguards to be applied when adding category 2 territories to be specified list in the future, the integrity of the Interpol red notice system, the impact of losing access to the EAW, and what other measures might be necessary to mitigate against these risks. Again, maybe the Minister would give us some clarification in those matters that were expressed in the other place. I'm all for trade deals and for working in partnership, but not at the expense of lives. And as furious as those who are removed from our treaty list may be, doing the right thing may mean doing the difficult thing as well. Sometimes the more difficult thing is the harder to do, but it's a moral thing to do. It's the right thing to do, and that is why this legislation must be given the freedom to do so. I welcome government's commitment to legislate, to change, and the introduction of the Majeski Bill that the Secretary of State referred to. I think is something that we all supported. I am a great admirer of America. It's not just because I go there on holidays every 2 or 3 years, but I love the American people. I love the escapism that America has. And I'm proud of my Ulster Scots foundation and my history and my tradition, and I'm very pleased to say for the record that 18 of the Presidents of the United States of America have Ulster Scots ancestry. So that tells you something about the wee part of Northern Ireland that I come from, that we can with just 18 Presidents of the United States of America. It tells you that there were fine presidents, by the way, it tells you that as well. But it also tells you that the history of the United States is all coming from here and from other countries in the world as well. I'm aware of the fact that our extradition policies may not be equally reciprocated, and when it comes to our dealings with the US of A, I believe this should be taken into account. Therefore, when I saw the amendments that the Honourable Gentleman for Halton, Price and Houghton has put forward, and others have spoken to as well, and others will probably speak to after me, I believe this should be taken into account. Therefore, when I saw the amendments that tabled and highlighted the US situation, gives me pause, I believe, and should give this House pause for great thought upon what we do. We all know the cases. I don't need to say them again, others have referred to them, but they're in my mind, they're in the media spotlight, so therefore they're very important. There have been various examples. Indeed, this year our Prime Minister was open enough to admit that it may be appropriate to characterise our relationship in relation to an extradition as lopsided. That was his words. I thought it really told us all about where the position is with the UK and the USA. It has been well argued that the current legislation in the 2003 treaty requires the UK to meet a higher evidential threshold, and I understand that. Before than the US before extradition will be ordered. It's abundantly clear that we must take steps to rectify this within the extradition bill, and I'm pleased that this does seem to be the case, and I think it does, but again the Minister will maybe give us some clarification on that. I ask a question, Minister, and just I think the Honourable Lady for Durham, I think I'm right in saying that's the right constituency, referred to the contact with the local administrations, the Northern Ireland Assembly, the Scottish Parliament and the Welsh Assembly. Just to confirm that those talks and discussions have taken place, and that the full input of what the regions would say as part of that deal. It would seem that there are certain nations who allow us to give but do not reciprocate at the same level, and this legislation must give the ability to the NCA, under authority of the legislation and the Secretary of State, to make changes to ensure that if we are at pains to help others to bring home criminals to be accountable for their crimes, then we get at least the same level of help when it comes to our own criminals. Hailing as I do from Northern Ireland, as others will remember in this House, I've said it in the past, I want to put it on the record. It was heartening to see men and women who carried out terrorist activities, leaving people with unspeakable loss, with pain, with injury, with hurt, and lives that would never be the same, wandering about in the Republic and living their lives in defiant freedom. Some of those who carried out some of the worst atrocities, Madam Deputy Speaker, have walked around the Republic of Ireland in comparative safety and sanctuary for some time. Those who killed my cousin Kenneth Smith and his friend Daniel McCormick on the 10th of December 1971 escaped across the border and have never been made accountable for their crimes. So you can understand how 49 years later you feel quite concerned. I have lived a life knowing that murdered criminals unrepentantly live their lives in freedom just miles across the border from their dreadful deeds. That's something I would wish in no one. Our extradition treaty must have the basic principle that we will help others to get criminals off the streets, but the underlying pin that holds it together must be that our moral duty, as the Honourable Gentleman has referred to, and I believe we all adhere to, and the duty to human rights is premium. It is my belief, Madam Deputy Speaker, that this bill is our opportunity to get it right, and I welcome some of the tidying up that has taken place by members of the committee, and we welcome their input and their commitment. A lot of work has taken place to get us thus far, but again, Minister of State, I ask for your assurance. Do you believe that our human rights obligations, Minister of State, is it that the human rights obligations are fully enshrined within this legislation, not simply for today's globe, but further proof for our ever-changing world? Thank you.
Caroline Noakes.
Thank you, Madam Deputy Speaker, and I appreciate the opportunity to speak very briefly in this afternoon's important debate. And there has certainly been some excellent contributions from honourable and right honourable members, and it's always a pleasure to follow the honourable member for Strangford. And many members have rightly highlighted the positives in this bill, but also some of the perceived negatives. I would echo the comments of the Honourable Member for Strangford when he said that we have a strong history of doing the right thing, of doing the lawful thing, even when perhaps there is an imbalance in relationships, as we occasionally do see. But I wish to approach this from a slightly different perspective, and I don't expect the Minister to be able to comment in detail on the issues that I raise. It would be extremely unfair of me to expect him to do so, but in fact, in every extradition case, whether somebody is a criminal or not, at heart there is an individual, and there is an individual whose human rights must be protected. And in that vein, I draw to the Minister's attention the case of my constituent Jonathan Taylor, who is currently fighting extradition on an Interpol red notice, because his is a case which highlights some of the issues and examples that my right honourable friend, the member for Halton Price and Howden, has expressed so passionately his fears at what could happen to individuals who, at the end of the day, are British citizens and our constituents. So as I said, I don't expect the Minister to comment in detail, but Mr Taylor is currently on bail in Croatia, where he is fighting an extradition notice from Monaco. And I note that Monaco is not included in any of the changes laid out in this bill, and I don't seek to bring in anything which might be considered out of scope, but wondered perhaps whether the Minister might be tempted to comment on the reasoning behind that. This is, of course, as I have quite rightly done, an issue I've raised with the Foreign and Commonwealth Office as his constituency MP, and I know that other members across this House have also highlighted this particular case because Mr Taylor is a whistleblower. And I'm seeking reassurances this afternoon from the Minister that in cases where whistleblowing is involved, that the individual who has done the right thing and provided the evidence to jurisdictions as far-flung as the United States, Brazil, the Netherlands, that they should not somehow find themselves caught up in a Kafkaesque nightmare where it is they who are held responsible and then find themselves fighting extradition in foreign countries when in fact they have done nothing wrong. And in this case, it is the whistleblower who is being pursued by Monaco, which leaves him in an extremely vulnerable position, which is causing great anxiety to himself and to his family. Hence the need this afternoon to raise these concerns with reference to this piece of legislation as it comes before the House today. As I said, in this country we seek to protect whistleblowers. There is legislation laid down in 1998 and in 2013 which does exactly that. And I am seeking reassurance from my right honourable friend the Minister that there is nothing contained within this bill that will undermine those protections for British citizens who find themselves caught up in this sort of situation. And I can see that Mr Taylor's case is not strictly applicable to this piece of legislation, but it is pertinent, and it would have been very remiss of me not to use the opportunity today. So I have done so. I have highlighted a very real situation that is of massive concern, not just to my constituent, but to other British citizens. Many others will be in similar situations. They are seeking to oppose their extradition to countries who are giving every appearance of pursuing a political rather than a judicial agenda.
Cherry.
Thank you, Madam Chairwoman. I rise to give my party's support to the amendments in the name of the Right Honourable Member for Chingford and Wood Green, and also those in the name of the Right Honourable Member for Halton Price and Howden. And I would also say that the Scottish National Party support the official opposition's amendments, new clauses 1 and 2, which both seem eminently sensible. Madam Chair, the Scottish National Party fully supports reasonable measures to keep our citizens safe from those who've committed serious crimes first of this country, and we fully support working with international frameworks to do that. Indeed, that's one of the reasons why we and the majority of people in Scotland were so keen on the security and justice cooperation afforded through our membership of the European Union, and why we voted for its continuance repeatedly and are so sad to see it go. But turning to the specific amendments here, it's important to remember that as well as a duty to protect the safety of our citizens, it's also the duty of this government and this Parliament to uphold international human rights standards. And we should be loath, therefore, to do anything to aid extradition to regimes which don't uphold the right to a fair trial, or to free speech or freedom of expression. And many of our constituents are extremely concerned at human rights abuses in China, particularly in respect of the Uyghur Muslims. These and other human rights abuses are indicative of a regime which is very far indeed from putting the same store by human rights as we do. And many of our constituents have watched with horror as the situation in Hong Kong has unfolded and as the brutal suppression of pro-democracy activists continues. And the Honourable Member for Strangford referred to that footage of a 12-year-old girl being subject to a violent arrest at a pro-democracy protest. And I'm sure we're all very grateful to those brave enough to film that footage and get it out to the rest of us. So I very much want to associate myself with the comments of those who are very keen to impress upon the Minister, and I'm sure he is alive to this, the importance of not making it any easier for human rights denying regimes to get their hands on their citizens who've sought refuge in these islands. Now, turning to the Amendments 7 to 10 in the names of the Right Honourable Member for Halton Price and Howden, I share his concerns about the unbalanced extradition arrangements we have with the United States of America. There's a lot that could be said about those today, Madam Chairwoman, but I'm not going to go into it in detail because it's beyond the scope of this bill to redress that imbalance. But I'm very grateful to the Right Honourable Gentleman for raising it, and I do wish to impress upon the Government as we move forward, particularly given the nature of the current President of the United States of America, that we should be looking afresh at these unbalanced extradition arrangements, particularly when we see their outcome in a number of high-profile cases at the moment. Now, I want to turn to the government amendments. I am keen to know from the Minister, I realise that in the last hour or so we've received a letter from him, but I've not had time to digest its contents properly. But I'm keen to know just exactly why Government Amendment 15 is now seeking to include EEA countries in the new Schedule A1. Is this the start of a growing and perhaps inevitable recognition that when we leave the transition period at the end of this year, there's not going to be any replacement for the European arrest warrant? Because if that is so, that is a most regrettable state of affairs, and it's a state of affairs that is of great concern to my colleagues in government in Edinburgh, and also to the Crown Office and Procurator Fiscal Service in Scotland and Police Scotland. So an update on exactly what's going on here would be very much appreciated, particularly as the Solicitor General told us at second reading that this bill was not about the European arrest warrant. If that has changed, then I think we really deserve a full explanation of why it has changed and where we are in the negotiations in that respect. Madam Chair, I wish to oppose Government Amendments 13 and 14. Government Amendment 13 is taking out a provision that was inserted in the other place, imposing certain conditions about a consultation, assessment and reports on the making of regulations under Section 74B7 of the Extradition Act 2003. And I very much regret that the Government are attempting to remove these additional safeguards. I regret in particular the Government's determination to remove the obligation to consult with the devolved governments before adding, removing or varying reference to a territory. I very much fear, Madam Chair, that this deletion is indicative of the Government's lack of goodwill towards the other governments of these islands. Now, it will come as little surprise to viewers in Scotland that this Government will do anything it can to get out of any obligation to take account of public opinion in Scotland or the views of Scotland's elected representatives. But in this respect, I would urge them to think again. Because as was said in the other place, the devolved institutions can be a source of valuable information relevant to the changes that might be proposed in relation to individual territories. And although extradition is a reserved matter, the Scottish Government and the Scottish Parliament have responsibility for justice, policing and prisons, and their views really ought to be considered. Furthermore, many members of the Scottish Government and Parliament have expertise in relation to human rights and a particular interest in human rights aspects of territories that the British Government might seek to add. And that brings me to the deletion of any obligation to consult with non-governmental or organisations. I've already spoken, Madam Chair, about how central human rights must be to our decision as to whether to add any territories to these provisions. And in relation to the human rights position on the ground of a particular country or territory, then NGOs will have direct experience or information which can only aid government decision-making and, importantly, parliamentary scrutiny. And finally, I wish to speak in support of the Honourable Member for the City of Durham, what she had to say about the unfortunate deletion of the obligation to do it territory by territory, one statutory instrument per territory, rather than rolling up a number of territories into one statutory instrument. As was said in the other place, by exiting the European Union, we have made ourselves as a state vulnerable to pressures in the context of seeking trade agreements. And if we have one statutory instrument per one territory, then it's much more likely to be identified on the floor of this House where such undue pressure has been brought to bear. And I think I'll leave it at that for now, Madam Chair. Thank you.
Shadow Security Minister Conor McGinn.
Dame Rosie, it's always a pleasure to see you in the chair and to follow the Honourable Lady from Edinburgh South West, with whom I've shared many assignments on the floor of this House and in committee on these matters. I rise to speak to New Clause 1, New Clause 2 and Amendments 16 and 17 in my name, that of the Leader of the Opposition and the Shadow Home Secretary. I must say, Dame Rosie, there is a slight irony that we are discussing a government bill designed to strengthen international law just a matter of hours after we heard from the dispatch box and the Right Honourable Gentleman's successor, but two, that the government intends to break international law in relation to the withdrawal agreement. I also want to put on record how good it is to see the Right Honourable Gentleman, the Security Minister, and I want to thank him for the cooperative and courteous way in which he has worked with me since I was appointed over the last number of months. I would expect no less from a person of his calibre, but it is very much appreciated. I think also we have heard from the serious tone of the debate and the points made, and it is quite daunting for a relatively new frontbencher to follow the speeches of such distinguished and senior parliamentarians in the form of the three Right Honourable Gentlemen, and also to hear from the Honourable Gentleman from Rothervalley and of course the esteemed Chair of the Equalities Committee, and of course my honourable friend from Durham, who shows that there are still a few raids left in the raid wall, thankfully, thankfully, Dame Rosie, and the characteristic dignified words of the Honourable Gentleman, my friend from Strangford. The extradition bill, this bill seeks to fill a gap, notably the situation where UK law enforcement becomes aware of someone wanted by a non-EU territory but are unable to arrest them without first seeking a warrant. And the risk that the bill seeks to address is that a wanted person may abscond or even reoffend before they can be detained. So we acknowledge the context, the arguments and the safeguards set out by the government at second reading, and we've taken careful consideration of the comments by the Director of Public Prosecution and others. And we also believe that the scrutiny and refinement that the bill has undertaken during its passage in the other place has significantly improved and strengthened it. And we've approached the bill in a constructive spirit with a determination to work across the House to get important legislation right for the protection of all our citizens, because it is of critical importance that we ensure serious criminals who, let us not forget, are in some cases wanted abroad for the most heinous crimes, they are arrested and swiftly brought to justice before the opportunity arises for them to reoffend or abscond. And in carrying out all of our overriding priority to keep the British public safe, we fully accept, in a world where criminals increasingly respect no national borders or boundaries, we must work to achieve this in collaboration with our international partners. But there are important amendments down today, and I hope the Government will listen carefully to the points raised on all sides of the House to ensure that we build the strongest and most robust and fair legislative framework for our extradition process. New Clause 1 would require the Secretary of State to lay a statement setting out how many individuals have been arrested under provisions within this Act, broken down by characteristics of each person arrested as set out in Section 4 of the Equality Act 2010. And this would ensure, Dame Rosie, that Parliament receives the information and facts to enable us to fulfil our duty in scrutinising the effectiveness and impact of this bill, and in particular to know who it is being applied to, because it's important to understand firstly how many people this is applied to, which will enable us to understand the breadth and reach of the provisions in this Act and to compare its effectiveness with current provisions. Secondly, it is equally important that we understand to whom it is being applied. The purpose of the Equality Act was to protect people from discrimination on the basis of 9 protected characteristics. And in a situation like requests for extradition, where we are responding to requests from other jurisdictions, we do not have any way of recognising these requests, whether these requests are forming any patterns or disproportionately affecting any group of persons. And if our own equalities legislation is to have any meaning or be effective, it's vital that we at least have the evidence and the data before this House to analyse the effect of these extradition provisions on protected groups. And we therefore request that this information is published to enable this analysis so we can more effectively understand the impact of the bill. New Clause 2, in my name and that of my right honourable and honourable colleagues, requires the change made by this Act to be kept under review and the first review of the Act to be carried out within a year of it being passed. Again, this is an important part of making the legislation better, because we live in a permanently changing world where both international relations and the issues of crime and security are fluid and constantly evolving. Moreover, there remain concerns from many areas about the approach of several countries to the use of Interpol raid notices, as we've already heard. In February last year, the European Parliament published a study that examined abuse by some states of Interpol's notice system to persecute human rights defenders, civil society activists and journalists in violation of international standards of human rights. The study acknowledged that the reforms implemented in 2015 have improved the situation. However, abuses of the Interpol system against individuals, including journalists, continue, because there is still a lack of established rules and procedures to govern the vetting process in adherence to Interpol's constitution. It is therefore of utmost importance that we in this House have the opportunity to finesse or refine this legislation in respect of extradition so that weaknesses in existing systems are not exacerbated by any vague legislation coming from this House. So it is important that it is regularly evaluated, and like our New Clause 1, it is only through comprehensive access to good information and evidence that we can truly understand the impact and effectiveness of this important legislation. So I hope the Minister, I will of course.
A very good point. Has he done any study of the impact of the European arrest warrant and whether that's had adverse consequences in the way that he thinks Interpol has?
Right Honourable Gentleman for his intervention. I will come to the European arrest warrant and that point very shortly. So I hope the Minister recognises the importance of these clauses to the effectiveness of the bill and responds accordingly. On Amendments 12, which is Government Amendment, and Amendment 16, which defines the designated authority as a national crime agency, we recognise that and we're pleased to see that the Government has moved an amendment to that effect. And I have no doubt that this will give an important sense of clarity and purpose to those brave men and women working in the National Crime Agency and their operational partners, whose efforts, let us not forget, right at this moment in fact, do a great deal to keep the public safe and secure. And the role of the designated authority is fundamental to the success of the legislation, given that it will be carrying out the functions of certifying requests. But can I ask the Minister, will he confirm to the House that powers of redesignation, if ever necessary, will be open to scrutiny by both Houses of Parliament, because I think he'll appreciate that's an important issue in terms of future oversight. On Government Amendment number 13, Dame Rosie, we feel it seeks to undo a valuable amendment made in the other place by my Honourable Friend the Noble Lord Kennedy of Southwark, which received support from all sides in the other place, and it requires certain key conditions to be satisfied before the Secretary of State can add, remove or vary reference to a territory. This amendment, I think, was reasonable, proportionate and practical, and it should present no problem to the Government, so I'm not quite clear why the Minister is seeking to undo the good work done by the noble lords this afternoon in the other place. Mr Speaker, Dame Rosie, nothing in this amendment stops the Government doing what they want to do. It simply ensures a proper process of consultation and assessment which any major changes to a framework of this significance should undergo, because where the proposal is to add a territory, it requires a statement confirming that the territory does not abuse the Interpol Red Notice system. The first part of the amendment places a requirement on the Secretary of State to consult on the merit of the change, and there are two groups in the consultation proposed here. First, the devolved institutions, and secondly, NGOs and civic society. As the bill currently stands, after consultation and assessment is to be laid before Parliament, outlining the risks of the proposed changes and confirming that where the proposal is to add a territory, it does not abuse the Interpol Red Notice system. And it's my contention that the bill and that should remain as such. In a similar vein, we'll also be defending the amendment made in the other place by Baroness Hamway, which the Government is attempting to remove by its Amendment 14. The bill as it now stands requires each order to add, vary, remove a territory under Schedule A1 to contain no more than one territory. Now, there is, of course, nothing to prevent the Government laying several instruments, each relating to one territory, at the same time, so there should not be any delay to process. Because, of course, each country will have differing characteristics and varying degrees of compliance, so grouping them could result in the waving through of some territories with questionable human rights record, purely because to fail to do so would jeopardise a potentially urgent extradition agreement with another country. Each country will have varying levels of compliance and different approaches to issues of human rights and criminal justice, and this is important because whilst we agree with legislating on the basis of those currently specified as trusted partners in this bill, we shouldn't leave the door open, and we intend to defend the inclusion of this clause as a safeguard for the effective application of this legislation. Amendment 17, which we have placed in order to allow all European Economic Area member states to be inserted into new Schedule A1, and we note that the Minister has done so similarly under Government Amendment 15. But frankly, the lack of progress on justice and security talks with the European Union gives us a great deal of concern. The 31st of December is approaching with no positive signs of agreement on these hugely important issues in place. So I would ask the Minister today, is he concerned about us losing access to the capabilities afforded by the European arrest warrant? Because we are clear on this side of the House that any loss of capability, regardless of whether it is mutual, would have disastrous implications for UK law enforcement's ability to identify and question suspected criminals and thus keep our country secure. Indeed, I refer the Minister to comments made in February 2019 by Deputy Commissioner Richard Martin, UK law enforcement lead for Brexit and international criminality, in relation to the loss of the European arrest warrant, the Schengen information system and the potential implications of a no deal on policing. He said, every fallback we have is more bureaucratic, it is slower. Policing is not going to stop. Of course, policing will meet the threat, but we are going to be much more limited than we currently are. And he went on to add, if something takes 2 or 3 times longer than it was taking before, that's another couple of hours you're not back on the streets and you're not being visible doing whatever your core role is. Such an outcome, therefore, I think would not simply be undesirable but unacceptable. And specifically on extradition, we know that the UK and EU falling back on prior arrangements, the 1957 Council of Europe Convention, would complicate proceedings, adding needless delay. And that's not my assessment, but that of the previous Conservative government and the former Prime Minister, the Right Honourable Member for Maidenhead. So specifically, while we entirely accept the bill's scope solely relates to powers conferred upon UK law enforcement, I would like to ask the Minister what exactly the Government is doing to ensure adequate levels of reciprocity in future extradition arrangements, particularly if we lose the powers we presently enjoy under the European arrest warrants and other such mechanisms. I just would like then Dame Rosie to briefly turn to the amendments in the names of the Right Honourable Member for Chingford and Wood Green and other colleagues. And I've listened carefully to the powerful speech he made today, but the admirable work that he has been doing over previous months on this issue, which is wholeheartedly supported by those of us on this side of the House. We welcomed the government's decision to suspend the extradition treaty with Hong Kong. We feel it will offer much needed assurance to the Hong Kong diaspora and pro-democracy activists, and it's important that the UK works with democratic partners around the world to ensure a coordinated international response that enables the holders of a British national overseas passports, pro-democracy activists and the people of Hong Kong to travel without fear of arrest and extradition. The government must not waver in its commitment to the people of Hong Kong, and we will support them in their endeavours if that is the case, and I look forward to hearing the Minister's assurances. And I also want to acknowledge the work of the Right Honourable Member for Halton Price and Howden and the amendments that he has made. And as stressed before, we acknowledge the bill's scope relates predominantly to powers of arrest conferred on UK law enforcement, not the extradition process itself. But having said that, we need to do all we can to ensure levels of reciprocity when it comes to our extradition agreements, not least with our most trusted partners. It's not acceptable that we're not able to bring justice to those wanted for serious offences here in the UK because they are elsewhere, while the reverse would be perfectly possible and is all too often the case. Because for an extradition agreement, and this goes to the heart of the point the Right Honourable Gentleman made, for an extradition agreement to have any value, British citizens must believe their government will support them and stand up for them and uphold the integrity and equivalence of any agreement. And I hope the Minister will take these arguments seriously. So in conclusion, Dame Rosie, as always, we have sought to be a constructive opposition during the progress of this bill, and our amendments set out today serve only to strengthen and improve this legislation, building on the cross-party work done in the other case.
Security Minister James Brokenshire.
Thank you, Dame Rosie, and it's a privilege and pleasure to serve under your chairing of today's debates. And can I thank all honourable and right honourable members across the House for their contributions during the course of this thoughtful debate, and how I recognise and appreciate the support that has been given to the principles that are enunciated within what is a short bill and within a defined purpose. Can I thank my right honourable member, the member for Chingford and Woodford Green, and I will come to his amendments in relation to the important points which he makes in relation to Hong Kong. My right honourable friend, the member for Halton Price and Howden, my long-standing friend, I will turn to his comments on extradition. Indeed, these are ones that he and I have debated over many, many years, and he will remember the changes that were brought about on things like forum bar, and where the right forum actually is, and provisions that were brought about there. And so I can certainly say to him that we will always keep our extradition arrangements under review. Also, the contributions from the honourable member for the City of Durham. Thank you for your challenges, and I will come to those during the course of my contributions. My right honourable friend, the member for Wokingham, obviously there are issues around the EU and how we negotiate, and actually how we do use the freedoms that we now hold as an independent state, and the negotiations that are very much extant in relation to the EU, which I will hope to explain further. Thank you to my honourable friend and member for Rother Valley for your support and for so clearly setting out the purpose of the bill, as well as, of course, the contributions of the honourable gentleman for Strangford. And he made a number of wide-ranging points, and indeed I think underlining the utility, the purpose, why we have extradition in holding up our justice system and ensuring that those who need to be brought to justice indeed are, and such are significant cases that we know touch so many of our constituents. And indeed, in that note, I appreciate the comments of my right honourable friend, the member for Romsey and Southampton North. I can certainly say to her, in relation to the individual case that she references, that we are most clearly aware of the constituency case that she highlighted, and I can certainly say to her that we are working with colleagues at the Foreign, Commonwealth and Development Office in connection with the case that she did raise. And I think it's important in that context to highlight, I think, the way in which we do approach this on ensuring that appropriate standards are met and applied, and how she sought to underline certain issues. I won't comment in terms of the detail of the individual case that she raises for her constituent Jonathan Taylor. But what I would say to her is that this bill does not change the role of the Court or the Secretary of State in relation to a person's extradition or any of the existing safeguards in the Extradition Act. No individual will be extradited if the request is politically motivated. And I think that was the broader point that she was seeking to highlight, so perhaps I can give her that assurance. Dame Rosie, the purpose of this bill is to create an immediate power of arrest for UK law enforcement when they first encounter extradition fugitives in certain circumstances. It introduces a new power of arrest by amendment to Part 2 of the Extradition Act 2003, makes necessary consequential amendments, and provides a power to make further consequential amendments by regulations. And I appreciate the warm and generous comments that the Honourable Gentleman for St Helens North raised in relation to the broad support for the bill. And can I thank him for his kind personal comments too. And I do wish him well and look forward to, no doubt, many discussions in the future over a range of issues straddling security, organised crime, and more broadly into the themes of extradition that we're touching on today. Currently, we do not have an equivalent power to arrest to that under the European arrest warrant for extradition purposes for those wanted by non-EU countries. Instead, at the moment, our police have to apply to a UK court for an arrest warrant before they can arrest fugitives wanted by those countries. By creating the power to arrest certain suspects immediately without obtaining a warrant first, we are ensuring that if the police come across an individual wanted by a specified country whose systems we trust, they can arrest them. This prevents any risk they might pose to the public here in the UK if they are left on the street, and the risk that they may abscond and not be brought to justice. And I think it's important to express it in these terms. This bill is about protection of our citizens in this country. It is a judgment, a determination that we make that this is an important right, an important power for our police to have, bounded by, of course, appropriate safeguards. Because we know that some fugitives wanted for extradition can sometimes come to the attention of the police through a chance encounter. That is why the ability to arrest a suspect immediately is an operational necessity. And that power is created by this bill. I will give way.
Thank you very much, Dame Rosie, for allowing me to intervene. I thank the Minister for allowing me. How long do the police have when they make this immediate arrest before they've got to allow the suspect to go?
My honourable friend actually makes an important point about issues of safeguards, and he will see that the arrested individual will need to be brought before a judge as soon as practicable after arrest. It's one of the safeguards that I wanted to highlight that I think underpins this bill. The new arrest power in the prescribed circumstances is the only change, and I think this is another important point for me to stress, the only change to current extradition law and practice that is introduced. It is designed to bring a wanted person into extradition proceedings under Part 2 of the Extradition Act in an expedited way without changing the likelihood of successful extradition. It does not change the current legislative framework nor any of the process for the extradition proceedings themselves. The bill is purely about shifting the point at which the police can intervene and arrest a wanted person. It in no way reduces the safeguards that must apply to any subsequent extradition proceedings considered by the court or the Home Secretary. Judicial oversight will continue as it does now. After any arrest, the courts will continue to assess extradition requests as they do now to determine, for example, whether extradition would be compatible with the individual's human rights, or whether the person would receive a fair trial. If they would not do so, extradition would be barred. So the bill includes 5 main safeguards. It only applies to certain specified countries. Countries with a poor human rights record or who have abused Interpol systems could not be considered suitable for this provision. The addition of any countries would require the consent of both houses. It only applies to sufficiently serious offences. The power would only be available in relation to offences which would be criminal in the UK, for which an offender would receive a prison sentence of at least 3 years, and which is sufficiently serious form of that offence to justify arrest. The designated authority must be satisfied. Arrangements are in place to ensure that requests made by the country concerned are made on the basis of an underlying warrant or a conviction. Also, as I've indicated, the arrested individual will need to be brought before a judge as soon as practicable after arrest, and the power does not alter extradition proceedings in any other way and does not interfere with the Court or the Secretary of State's role in extradition proceedings. So I think that sort of, I hope, sort of sets out quite clearly the importance of the safeguards. I know that some raised the issue of Interpol, and I would like to stress that the UK continues to work with Interpol to ensure its rules are robust, effective and complied with. And I think it's notable that the former Chief Constable of Essex was recently made the Executive Director of Policing Services for Interpol, the most senior operational role in that organisation. And a UK government lawyer has also been seconded to the Interpol's Notices and Diffusions Task Force to work with them to ensure Interpol rules are properly and robustly adhered to by Interpol member states. Can I just quickly turn to the Government amendments standing in my name? Government amendments 11 and 15 I'll take together. This group together as a contingency to keep an important current law enforcement protection for the UK public in place after the end of the transition period, whatever the outcome of the current negotiations. As this House knows, the negotiated outcome we are seeking with the EU would create a warrant-based system based on the EU's surrender agreement with Norway and Iceland. The purpose of amending the bill in this way at this time is to ensure the continuation of relevant arrest powers should it prove necessary. This amendment is a consequential amendment which will ensure that Amendment 15 only be commenced if we do not have in place new extradition arrangements with the EU at the end of the transition period. If an agreement is reached, it will not need to come into effect. It is simply a contingency. Similarly, it provides a contingency in the event that we do not agree new extradition arrangements with Norway and Iceland to maintain the arrest power currently available by virtue of the EU-Norway-Iceland surrender agreement. In terms of the opposition's Amendment 17, I note that this covers similar ground, albeit framing this in the terms of the EEA. I hope the honourable gentleman will appreciate that we do, I think the purpose is that we should approve participants on a state-by-state basis, and I think he probably acknowledges, and therefore that is why we think the better approach is to name countries individually. In relation to the progress of the negotiations on law enforcement and criminal justice, I think there is a good degree of convergence in what the UK and EU are seeking to negotiate in terms of operational capabilities, and we will keep working to bridge the gap where differences remain. There is still an agreement to be had, and we will continue to work hard to achieve it. Amendment 12 specifies the National Crime Agency is to be the designated authority for this legislation. The designated authority is the agency which will have the task of certifying the international arrest alerts that conform to the right criteria for them to carry this new power of provisional arrest. The drafting remains future-proofed as it allows for the designated authority to be changed by regulation should that need arise. We've taken this approach as the direct alternative to using secondary legislation on this occasion, in order to ensure that we use the best use of parliamentary time. And this amendment therefore represents a change of process rather than policy, and indeed I think sort of reflected in terms of the amendment that was tabled by the official opposition in terms of their Amendment 16. But I hope that because of this future-proofing arrangement, that they will recognise that we hope is and see as an improvement to the technical approach that they're taken. On Amendment 13, which overturns one of the two changes made in the other place, statutory requirements are added for the government to consult on the merits of adding, removing or varying a territory from the bill with the devolved administrations and relevant interested stakeholders. Throughout the passage of the bill, we've been clear in our commitment to ensuring that Parliament can scrutinise any decision to bring a new country in scope of this power in exactly the same way as Parliament does in relation to the Extradition Act. To that end, the bill mandates that the addition or removal of any territory is by the affirmative resolution process. This gives Parliament the right to scrutinise in detail such proposals and to accept them or indeed to reject them. And I think it's important to stress that whilst extradition is a reserved matter, relevant officials are engaged in regular discussions with their counterparts in the devolved administrations and law enforcement agencies who operate right across the UK to collaborate on operational policy and ensure the effectiveness of our extradition system. Indeed, discussions, consultation such as this has already taken place in relation to the bill and the amendments we are considering today. Of course, given that any countries being added will be subject to the affirmative procedure, there will be opportunities for Parliament to probe on this issue and the extent to which the views of the devolved administrations and other organisations have been sought. Therefore, we believe there is no need to add that onto the face of the bill. And in terms of Amendment 14, this overturns the second provision altered in the other place, which provides that the removal or addition of a country must use a single statutory instrument. Any additions will be dictated by the will of Parliament, not by, I think, an unusual process that this is what would be imposed. If there's a country proposed that Parliament does not agree should be specified, then the regulations will be voted down in the normal way, and we judge that that remains the rightful process. Turning to Amendments 1 and 2, in the name of my right honourable friend, the member for Chingford and Woodford Green, I'm grateful to him for the way in which he has approached this and the, I think, important points that he and other members have made in the House today. And in addressing this amendment, it might be useful to set out the measures the government has taken in dealing with the situation in Hong Kong since the amendment was tabled. As this House will be aware, because of the new national security legislation in Hong Kong, the government has indefinitely suspended the 1998 UK-Hong Kong Agreement on the surrender of fugitive offenders, our extradition treaty. As a result, this government will not deal with extradition requests sent by Hong Kong to the UK under that treaty. We are also creating a new bespoke immigration route for citizens from Hong Kong to come to the UK, reflecting the unique and unprecedented circumstances in Hong Kong and the UK's historic and moral commitment to British nationals' overseas citizens. And I would like to pay tribute to my honourable friend and members across the House who have brought this issue to the House and ensuring that we stand with the people of Hong Kong. This government has demonstrated its absolute commitment to the people of Hong Kong, and any changes to this bill in the form of this amendment would not change our extradition relationship with Hong Kong, as I think that the honourable gentleman has recognised. But the points that he has made are very powerful, and I know that colleagues in the Foreign Office will equally have recognised the points that he has addressed this afternoon, and we certainly will keep this issue under careful review. In relation to the amendments made by my right honourable friend, the member for Houghton, Price and Howden, I would reiterate that the purpose of this bill is to rectify a policing capability gap in order to better protect the public. I recognise that the points that he is making are perhaps in a broader purview, and that his amendments were probing, and he recognises that there are other issues that perhaps he would like to return to on another day. I would say that the US is just one of the UK's extradition partners, and the legal processes in each of those jurisdictions will be different. And I know that my right honourable friend has been a champion of the important liberties that this government seeks to protect in relation to each and every extradition case that goes to the UK courts. And I recognise and respect the approach that he takes. Whilst I think we do take a different view on perhaps these issues of imbalance, and he will recognise some of the previous reviews that have preceded this in terms of looking at these issues in the past and seeing whether that imbalance does exist or not. But as I have already indicated to him, we do keep all of our extradition arrangements under review, and I no doubt look forward to continuing this conversation with him in the weeks and months ahead. I'm also grateful to him for referring to the case of Anne Secoulis, which he rightly drew attention to. Harry Dunn's death was a terrible tragedy. We have every sympathy with his family for their tragic loss and share their desire to ensure that justice is done, and a point that the Prime Minister himself has reaffirmed in the last few days. Can I turn to New Clause 1 and New Clause 2 finally? Throughout the passage of the bill, there has been considerable cross-party consensus on its aims and measures alongside the robust scrutiny that I've come to rightly expect from this House. This amendment requires the publication of an annual statement on arrests. What I would say is that the National Crime Agency already keep data and publish statistics around arrest volumes in relation to Part 1 of the Extradition Act. They do this without having been required to do so by primary legislation. We have no doubt that they will similarly do so in respect of arrests under this new arrest power, as this is sensible operational practice. And whilst I have some sympathy for the amendment, I'm not persuaded of the necessity as a statutory obligation at this time, and I hope that we will be able to review this as that information is published. And finally, in terms of the last remaining new clause around some of the other issues, again, I sort of again hear what the Right Honourable Gentleman has said in relation to this, and he, I think, sort of makes this in a probing way on the sort of review basis and things like that. Again, we believe that there is sufficient transparency and that this House no doubt will have that chance to be able to assess the operation of this bill and indeed the normal post-legislative scrutiny that can apply. And so for those reasons we are not minded to accept his amendment, whilst recognising the need, I'm sure, for constant challenge through this House. But I'm very grateful to the amendments that have been laid and indeed the informed debate that we have had.
Sir Iain Duncan Smith.
Madam Deputy Chairman, Deputy Speaker, I've listened very carefully to my right honourable friend, and given the nature of what the government has already undertaken since those amendments were laid by myself and my honourable friends, I will beg leave of the House to withdraw them.
Is it your pleasure that the amendment be withdrawn?
Aye.
Amendment by leave withdrawn. The question is that Clause 1 stand part of the bill. As many as are of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move Government Amendment 11 to Clause 2 formally.
Formally.
The question is that Amendment 11 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that Clause 2, as amended, stand part of the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move Government Amendment 12 to the schedule formally.
Formally.
The question is that Amendment 12 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. I call the Minister to move Government Amendment 13 to the schedule formally.
Formally.
The question is that Amendment 13 be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No. No.
Division, clear the lobby. Order. Order.
The ayes to the right, 333.
The noes to the left, 241.
The ayes to the right were 333. The noes to the left, 241. So the ayes have it. The ayes have it. Thank you. I call the Minister to move Government Amendment 14 to the schedule formally.
Formally.
The question is that Amendment 14 be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No!
Division! Clear the lobby! Order, order.
The ayes to the right, 333. The noes to the left, 244.
The ayes to the right, 333. The noes to the left, 244. So the ayes have it. The ayes have it. Thank you. Order. I call the Minister to move Government Amendment 15 to the schedule formally.
Formally.
The question is that Amendment 15 be made. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. The question is that the schedule, as amended, be the schedule to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. That concludes proceedings in committee on this bill. Order, order. Thank you. Order. Whip to report.
I beg to report that the committee has gone through the bill and directed me to report the same as amended to the House.
Thank you. No amendments on consideration. I call the Minister to move third reading.
Thank you, Madam Deputy Speaker. I beg to move that the bill be now read a third time. Can I thank honourable and right honourable members from all parts of the House for their scrutiny of the bill through its passage. I'm grateful to everyone who's contributed to the debate in committee today and at second reading before recess. Bills which relate to extradition are not always the easiest. And can I thank all members for their, I think, really informed, stimulating interventions and amendments that I think have helped shape and help inform the bill. There is no doubt that important contributions were made by many, and as ever, the scrutiny this House provides continues to test and improve the legislative programme that the government seeks to pass into law. All of us benefit from the work of officials from the Home Office on this side, and also can I pay tribute to the officials in the Public Bill Office and all those who have supported the bill's passage. This bill is designed to bring a wanted person into extradition proceedings in an expedited way, without in any way changing the likelihood of successful extradition or the legal process itself. It is in that way about ensuring that our police have the right powers to keep the public safe and bring those who may flee justice before justice as appropriate. This extension of police powers in limited circumstances, specifically to protect the public, does not in any way interfere with the ensuing extradition process. It is only about how suspects enter that process and minimising the risk that a wanted person could evade justice. There are powerful public policy reasons and benefits to ensuring that those wanted for extradition for serious criminal offences enter the extradition process as quickly as possible. And UK laws do not create the possibility of impunity for those accused or convicted of such offences. I would like to thank members from across the House for their support of the principles and indeed this bill today. and in making amendments and proposals which will ensure that we can continue to keep UK citizens safe. Throughout its passage, the bill has not lost sight of our ultimate aim, which is to provide UK police officers the arrest powers that they need to keep up with the challenges of transnational crime. Crime which is often organised and often has more than one victim in more than one country. This law will prevent fugitives responsible for such crime continuing to evade justice through an operational loophole which puts the public at risk. This bill closes that gap, and I am pleased that we have been able to reach a position of broad consensus on all of the bill's provisions, and I very much appreciate the support, but equally the scrutiny that's been applied through its passage today and previously, and therefore commend the bill to the House and commend the effect that I believe it will have in a positive way to protect the public.
The question is that the bill be now read the third time. Shadow Security Minister Conor McGinn.
Thank you as always, Madam Deputy Speaker. And I echo what the Right Honourable Gentleman said in thanking his own officials in his department who have been courteous and helpful and provided us with information and briefings throughout, alongside the Right Honourable Gentleman himself, but also officials in this House and the Public Bill Office for the diligent work that they have done and for their assistance in helping the official opposition and our colleagues across the House in scrutinising this bill. Madam Deputy Speaker, I don't intend to detain the House very long. We had a good and wide-ranging debate at second reading. I feel the bill has had good scrutiny in committee on the floor of the House. Today, while we are disappointed, although not entirely surprised, that the government didn't accept our amendments, we will not be opposing the bill at third reading. We have always said that we accept the need for comprehensive legislation to address the gap that currently exists for UK law enforcement prior to extradition proceedings. We hope this bill will assist closing that and help keep the British people safe. And we are determined that serious criminals who make their way to our country or commit offences in other countries cannot rest easy on our streets and evade the full force of the law. And we believe that the bill will help achieve that. Madam Deputy Speaker, in conclusion, all I would say is that we discussed at committee stage the need for an extradition agreement to have integrity, and that for it to have value, British citizens must believe that their government will support them and stand up for them and uphold that said integrity of any agreement. We've talked a lot about reciprocity, but I also want to talk about credibility, and I would just say gently to the Right Honourable Gentleman, the credibility around international agreements and international law isn't given in isolation, and it ill behoves a government on something as sensitive as this to talk about wilfully breaking international law, and I hope that he and his colleagues will consider that in relation to other matters, but in relation to the substantive matter of this bill, we will not be dividing the House this evening.
Joanna Cherry. Thank you, Madam Deputy Speaker. I was remiss earlier in not welcoming the Minister back to his place, and I'd like to thank him for his courtesy, as always, in keeping me appraised of his intentions in relation to this bill. The Scottish National Party supports the principles behind the bill, and we support reasonable measures to assist in tackling transnational crime, provided the importance of protecting human rights is respected. And as I said earlier, the Scottish National Party fully supports working with international frameworks to keep our citizens safe. That's one of the reasons why we and the majority of people in Scotland were so keen on the security and justice cooperation afforded through our membership of the European Union, why we voted for its continuance repeatedly, and why we have been so sad to see it go. I'm not going to divide the House, but I do regret the Government's refusal to countenance an obligation to consult with the devolves when adding or removing or varying a provision in relation to a territory. The devolved government in Scotland has a very real interest here, given the devolution of criminal justice. And as I said earlier, I think it indicates the lack of respect from this government to the impact of the devolved settlements on our constitution that no consultation is being forthcoming. It's also perhaps an indication of the ignorance of the fact that Scotland's separate legal system is protected not just by devolution, but by the Act of Union. And I've recently expressed concerns about potential breach of Article 19 of the Treaty of Union by the government's proposals in another field of law in relation to judicial review. And picking up on what the honourable gentleman who speaks for the official opposition said, it seems now that the Treaty of Union is not the only international treaty that this government are bent on breaching. And I would add my voice to that of the honourable gentleman who speaks for the official opposition. It is extremely shocking to see a government minister stand at the dispatch box and confirm that the government intends to breach international law. And I'm sure as I speak, the law officers who advise this government, the Attorney General, the Solicitor General and the Advocate General, the UK government's law officer in Scotland, will be very carefully considering their position, as will, I'm sure, the Lord Chancellor, who's bound in terms of the Constitution Act to respect the rule of law. And I look forward over coming days to see what the British government's law officers have to say about their position, and indeed the Lord Chancellor's position in relation to a government that promises on the floor of this House to break an international agreement and break international law. This seems to be one of the many unfortunate consequences of our leaving the European Union. And as I said earlier, it was notable that the government sought to amend this bill today in order to provide for the situation that there will be no replacement for the European arrest warrant when we exit the transition period at the end of this year. This is a most regrettable state of affairs. It seems that the United Kingdom under this government is intending to pilot us into a period of lawlessness. And for those of us who wish to see Scotland take a different path and who are rather sick of being lectured about how inappropriate that is, this course of lawlessness is most to be regretted. Thank you.
John Redwood. Madam Deputy Speaker, we've had a good debate earlier today, but I hope the Minister will come back to this House ere long on a couple of very important issues which were explored in the earlier debate. The first is the protection of British citizens who are the object of one of these extradition requirements once we've entered into these agreements. And I think my right honourable friend, the member for Houghton, Price and Howden, made a very powerful speech about how we need to look very carefully at the conditions that are offered to people when they are taken abroad on charges, particularly as they may be innocent, particularly as they may not be the most serious offences which most of us had in mind when these extradition regimes were drawn up. We all wish to keep our country safe. We all understand you need reciprocal agreements to do that. We wish these to be used to pursue those who are violent and commit the most serious crimes, but we need to think about how this can be extended and how in certain jurisdictions where we have extradition agreements they may not be accorded the same decent treatment that we would want to accord somebody who was charged with a crime but who may in the end prove to be innocent. And I think the other thing we need to come back to is how we are going to handle our arrangements for extradition with other European countries, because we are still not sure how this might work out, and we fully understand that this is still the subject of various discussions and negotiations, and I think it was entirely prudent to make some provision today. But some of us think that if there is to be no European arrest warrant when we have completed our implementation period, so-called, that could be an opportunity that we could have a better and more suitable system, because there were features of the European arrest warrant that were not to this country's liking, and there was an element of compromise in it, as there has to be. So I hope we will soon have some greater guidance on what might materialise. And as two of the other speakers in this third reading debate have referred to a topical issue which goes a bit wider than this bill, perhaps I may be permitted also briefly to do that. I have not heard or seen anything that implies this government wishes to break the law or the international treaty. I've seen everything to say that this government takes Clause 38 of the European Withdrawal Act very seriously, which was the assertion of sovereignty, and that it was a very fundamental proposition of the political agreement and the withdrawal agreement that the EU willingly entered into, that British sovereignty was going to be assured and central, just as it was very central to that agreement that there would be a free trade agreement. If there can be a free trade agreement, the other legal issues fall away. So, Madam Deputy Speaker, I think one did need to correct that rather wider point. But in conclusion on this bill is a necessary bill. There are issues arising from it that could warrant further thought and further treatment. And I do hope this government will take the advantage of that thought which leaving the EU can provide, to look again at how in the future, in the longer term, we have a good judicial relationship, cooperative relationship with the EU, which is fair to both sides and fair to any innocent people in Britain who may have to stand trial abroad.
Jim Shannon.
Thank you, Madam Deputy Speaker. Can I just say a very few quick points? First of all, can I say just how I did say to him in the voting lobby, what a pleasure it is, Madam Deputy Speaker, to see the Minister in his place and looking so well, so healthy. I told him I don't think I've seen him looking as healthy for a long time. And he asked me how my constituency was, and I said it's getting more beautiful every day. You know, but he knows that, and as the Minister knows that, and I know that as well. So I'm very pleased to see him back. Thank you. Oh, incredibly pleased to see the Shadow Minister. He and I have been good friends for a long time. Might have a difference of a political opinion in some things, but we do agree and a lot of things which are really important in this House on behalf of our constituents, and it's good to do that. The DUP supported the bill and voted with government. The extradition bill is now passed, and we have moved on to the next stage. Government and the Minister have given a commitment to speak up for those the world across, and the Honourable Member for Chingford and Woodford Green and the Honourable Member for Hutton, Price and Howden, and indeed myself and others spoke about the human rights abuses across the world, and maybe where the human rights angle of this extradition bill maybe doesn't just maybe give the everything we would like to see in place, but we're very, very pleased to see this moving forward. Across the world, there are those who are suppressed, those who are persecuted, those who are abused, and this law hopefully will make those people accountable where we can use this law for that purpose. Tonight, our government of the United Kingdom of Great Britain and Northern Ireland, I always love saying that, by the way, Madam Deputy Speaker, we're better together. And the Honourable Lady, of course, for Edinburgh South West might just have a slightly different opinion, but we would agree to disagree too much on it, I don't think, in a way. But if you do something wrong, you will be caught, and that there is a moral obligation to speak up. And I believe in this House tonight that we have taken a support for government in the legislation they've brought forward. We also have a moral obligation, I believe, and I think it's an important moral issue for us all to in this House that we speak about often. You cannot just do something wrong and get away with it. So legally and morally, tonight this House has made the right decision. I would love to see it, Madam Deputy Speaker, as we spoke about previously, that the Chinese government would be held accountable in the court of law, the moral law, the legal law across the world for what they do for others. There are many other countries like them, but tonight this country, our government, has acted correctly. Thank you.
Thank you. The question is that the bill be now read the third time. As members of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it.